Welcome, everyone, and thank you for joining us. Today's live stream is presented by Global Talent Immigration Law Group, where we focus on helping individuals navigate some of the most complex and high-stakes immigration matters. Over the past several months, we've seen a growing pattern, not always driven by one major announcement, but by a series of smaller changes that, together, are making legal immigration more difficult, more unpredictable, and in many cases, more stressful for visa holders, green card holders, and families. We're calling this Death by 1,000 Cuts. Today's discussion will take a closer look at what's actually happening, the policy shifts, enforcement trends, and procedural changes that are quietly reshaping the immigration landscape. Leading today's conversation is Liz Profumo, Managing Attorney of Global Talent Immigration Law Group. Liz works directly with individuals and organizations navigating complex immigration pathways, and she brings both legal insight and real-world experience to the issues we'll be discussing today. She'll walk us through what we're seeing, what it means, and what you should be paying attention to right now. We'll also be taking questions throughout the live stream, so feel free to share them in the chat as we go. Liz, thank you for being here. I'll turn it over to you.
Hi, everybody. Thank you for joining us today to talk about how recent immigration policies under the Trump administration are impacting people who are here legally. So we're going to take to talk about how immigration has changed for the people who are here and doing everything legally and correctly. So historically, immigration law practice had two tracks. Either we're working as attorneys, we're working for clients who are here legally and seeking benefits from USCIS, or we're working for clients who are not here legally and defending themselves from deportation in the immigration court system. And historically, they've been completely separate. But under this administration that's aiming for, a mass deportation policy, we're seeing the lines blurring more, where they're seeking to move people from the legal track to the deportation track. So, there's no doubt that there's some merit to the reasons behind all these new policies. Most of them are related to national security, and we all support national security. No one supports allowing violent criminals to immigrate to the U.S. So it's just a matter of how the policies are being implemented that I think is really sending shockwaves through the whole immigration system, and really leaving everyone feeling worried and anxious. In the past 15 months, we've seen a pattern of enforcement actions taken against groups that had never been targeted before, including green card holders who have had green cards for a long time and take a short trip abroad and are detained coming back home, or spouses of U.S. citizens who are going to their green card interviews, or workers that have valid visas. So most of the actions we'll be talking about, they happen to a relatively small number of people, or over a short period of time. But the fact that they never occurred before and happened, they leave us all wondering, am I next? What's going to happen next, and who is it going to happen to? And of course, this is a question that no one can answer with certainty. So it just leaves everyone with a low level of anxiety. And I believe that a lot of these actions, the fact that they are short in duration and don't apply to everybody, I think it's a strategy meant to make people feel worried and anxious in the hopes that they will just decide not to try to come to the US. I think overall they just had an overall chilling effect on people who are wanting to come here. So, to just recap some of the things that have happened, it all started, week one, right out of the gate. There were a flurry of executive orders. The southern border was declared actually a state of emergency, allowing for it to be militarized. refugee admissions were completely suspended for 90 days, so that humanitarian program first week was targeted. There was a mandate issued for all government agencies to put into place stricter vetting processes to try to root out anyone who had a criminal or other kind of problematic history. There was an order that actually told the Department of Homeland Security not only to focus on people with violent criminal history, but basically for anyone who was here out of status for any reason, that enforcement action should be taken equally against them, as well as other priorities, past priorities like violent criminals. They put in a policy saying that if you are detained, if you're arrested for immigration violations, that you are to be detained until your immigration court hearings. And this is, different from past policies, which really focused on making sure people go to court, but not requiring them to be detained. And of course, last but not least, they immediately signed an executive order challenging birthright citizenship, meaning that children born in the U.S. to non-U.S. citizen parents would no longer be U.S. citizens. So immediately after this one was implemented, several federal courts blocked it. And actually, it is now up for review by the United States Supreme Court on April 1st. So we're all going to stay tuned for that ruling. If this executive order is allowed to stand, it will really change a cornerstone of U.S. immigration. So that's, week one, that kind of set the tone. So that's the backdrop, that is behind everything else that happened. We started seeing, we had early on last year, the first stories, green card holders and, valid visa holders being detained upon entry for old crimes that USCIS already knew about. So, and I'm not talking about secondary inspection where they just ask you a couple questions. People were actually arrested and moved to detention centers for several days in some cases, or several weeks until they were able to get bonded out. We started hearing stories of people being arrested at green card interviews. So people who were going through the legal process to get their green cards, mostly through family members, sometimes through employers, doing everything right, show up for the interview and getting arrested by ICE. This was something that was extremely rare, prior to last year. We also started seeing people denied entry to the U.S. based on their social media posts. If they were posting anything that didn't agree with U.S. government policy, or if there was open support of Palestine and the conflict in the Middle East, that was, actually causing people to not be admitted to the U.S. Then in April of last year, an unprecedented action where nearly 2,000 international students had their F1 visas canceled overnight. Okay, so most of these people had some kind of something in their record from the past. Most of them, from what I understand, were very, very minor arrests or citations. Even getting a ticket years and years ago was causing the cancellation of the visa last year. Also, students who attended protests or showed open support of Palestine also had their F1 visas canceled. The first time I'm aware of in the past 20 years when nonviolent political speech actually resulted in immigration consequences. Luckily, those visas were all reinstated. I said actions were kind of for a short amount of time. So thankfully, they were all reinstated within 2 or 3 weeks. But I think the sudden mass cancellation really left everyone rattled, both the students, us as attorneys, and again, kind of leading to the question of, what's next. So in June last year, so we had the student visa cancellations, and then in June, they re-implemented the travel ban. So I don't know if everyone remembers the travel ban from the first Trump administration, but actually they had put in place the first week of the prior administration. Personally, I was surprised that they waited 6 months to reinstate it this time around. It started on a total ban of visas, no visas of any kind being issued to citizens of 12 countries, and then a partial ban on visas being issued for 7 countries. Okay, so that's where we started in June of last year. And as the year goes on, I'll revisit where we're at with that now. The next month, last summer, in July, they passed the big, beautiful bill. So this gave billions and billions of dollars to immigration enforcement efforts. So prior to 2025, so in 2024, ICE had 10,000 employees, and now they have 22,000. So in the past 15 months, they have more than doubled their staff. They are also using some of this funding to purchase large warehouse spaces where they intend to create immigration detention centers to house people that are being processed for deportation. Okay, later in the summer, August of 2025 now, the State Department launched what they call a visa bond pilot program. It initially only started with 2 countries in Africa. They're requiring citizens of these countries, if you apply for a tourist visa, to pay a bond of either 5,000, 10,000, or 15,000 US dollars. And that money is returned to them when they timely depart the United States. So it serves as a guarantee that people will not overstay their tourist visas. Okay, so again, it started last summer with 2 countries. In October of last year, they added a few more countries, all in Africa. And now it's actually, as of January of this year, it's 50 countries. They've added almost all the countries in Africa, as well as countries in Asia and the Caribbean. So citizens of many countries now are asked to pay a bond in order to get a tourist visa. Okay, now we're rolling into fall of last year, which is September. September was actually a pretty big month because they announced an overhaul to the H-1B program. So it now requires companies who are sponsoring workers on an H-1B to pay $100,000 for any worker who's outside the U.S. So when they first made the announcement, they did not specify that it was applying to people who were outside the U.S. The announcement just said any company sponsoring an H-1B, they're going to have to pay $100,000 per worker. Obviously, this sent large companies that have a lot of H-1B employees into a panic. The rule was refined over the next couple of weeks to clarify that now it only applies to employees who are abroad. This year's H-1B lottery is going on right now, so we don't have the final numbers. We won't have them until the end of the month. But there's no doubt that this increased fee is going to result in a decrease in people registering for the lottery as well as H-1B applicants. Okay, they also, while they were changing that program, they did implement a new program, which was the Gold Card, also in September. So it was introduced as an expedited pathway for anyone who wanted to gift $1 million per person, per family member, to the U.S. government, and this should result in expedited permanent residency. So as of now, immigration has not published any statistics about how many applications they've received. The only mention I can find anywhere of anyone being approved for this is Nicki Minaj. I don't know if anyone saw that she received a gold card, although she claims she did not pay anything for hers. So, the state of this $1 million gold card program is still a bit of a mystery at this point. Then as we kind of moved into 2026, the travel ban that I mentioned earlier was expanded. So the 12-country total ban was expanded to 19 countries and Palestine. The partial ban was extended from 7 countries to 20, but within a few weeks, it went from 7 to 20 to 75. Okay, so now there's citizens of 75 countries who can't receive tourist visas, student visas, or immigrant visas. So citizens of these countries, if they've been in a family-based immigration process, if there's a family member who has sponsored them and now they're at the end of the road and they just need to go to the embassy and get the visa issued, they are not able to do that at this time. Okay, so what we've also seen during this 15-month period is a rollback of a lot of very important humanitarian programs that allowed people to be here legally. So there is a status called TPS, or Temporary Protected Status. There were, let's see, coming into the Trump administration, there were 10, no, I'm sorry, going into the Biden administration, there were 10 countries whose citizens were eligible to apply for temporary protected status. And TPS is usually issued when a country is encountering some kind of crisis, which can be hurricanes, floods, sometimes civil wars. So we started with 10 countries going into Biden. By the end of the Biden administration, there were 17 countries that were eligible for TPS. In the past 15 months, the current administration has sought to roll back 12 of those 17 protections. So most of them are at various stages of litigation, but the intent to remove those protections, is clear. And if it was successful in removing all of them, it's estimated that 700,000 people would lose their status and their work authorization. There was also a humanitarian program that the Biden administration put in place that was targeted to citizens of Cuba, Haiti, Nicaragua, and Venezuela that would allow citizens who were already in some kind of immigration process to the U.S. to be paroled in legally so they could work and be with their family members. But that program was also canceled, and it was anticipated that about 500,000 people lost their status and work authorization when that program was canceled. So I think the policy that there are two, but the first of the two policies that impact the most people, I think, is the aggressive issuance of NTAs, or notices to appear. So a notice to appear is the document that starts the deportation process and asks someone to appear in immigration court, which starts the removal proceeding. So, and this is being enforced equally regardless of country of origin. It's really across the board. And, there's speculation that now they are using AI to make sure that these are issued in a very timely manner. So historically, applied for a work visa like an O1 or an H1B or an L1, and requesting a change of status within the US, if your petition was denied, you'd have plenty of time to make plans to leave the US. Okay, but now if you apply for a change of status and it's denied and you don't have an underlying status like a B2 or an F1, then you will definitely expect to receive an NTA to go to immigration court. So usually this is going to be about a month after the denial, but there are reports of some NTAs being issued at the same time as the denial. So, you really want to be careful about applying for a change of status with no underlying status. Okay, so another recent action that is impacting a lot of people is with the DMV. Okay, so recently, especially here in California, many of my clients are receiving notices from the DMV saying that there's an issue with your immigration documentation related to your real ID. In order to keep your real ID, you have to bring your immigration documents to a local DMV to, make sure that they're in order. And then when everyone goes, they're requiring that you have a valid visa in order to keep your real ID. And most, many non-immigrant visa holders, they don't travel frequently and don't have valid visas, which, are not required to prove your legal status. I know I talk about this a lot, but the document you need to prove you're legal, it's not a visa stamp. It is an I-94. So what the DMV has always needed to prove you're legal is your I-94. So now what they're saying is, well, so if you just have your I-94, the proof that you're legal, you can get a regular driver's license, but not a real ID. Okay, so and if that happens to you, it's fine. You can just get your regular driver's license. You don't need to have a real ID. Um, you can use your valid passport in place of a real ID, for boarding domestic flights, which is what everyone needs a real ID for. Okay. Um, so all this, if you're here legally, should you be scared? For most people, the answer is, probably not. Certainly, these are all reasons for all of us to be annoyed, but most people who are here legally still don't have anything to fear. So ICE is not knocking on the doors to round people up for, things like they don't like the way you answered a question on an application, or you just filed a petition, it was just denied. Is ICE going to come to your door and put you in the back of the van? No, so that's not happening. I did mention that you might expect a notice to appear in immigration court, which would mean you'd have this additional process you have to go through. But at the end of the day, people who are here legally will end up winning their case. Okay, so in the past, the chance of being deported or having to, go to court was essentially zero. So now, is it 1%? Is it 3%? 5%? I'm not sure, but it's still low. Okay, so please just make sure you're paying attention. Please don't post anything that might get you in trouble. And please don't let anything lapse or expire or slip through the cracks. Okay, so, and also this includes your passport. So if you're not sure if something is expiring or expired, please reach out to us, so we can let you know. And I think that's really what these are the policies that we have been seeing, over the past year and a half or 15 months, I suppose it's been. So, I know we got some questions in advance about how some of these policies are affecting people. So I'm going to go ahead and answer some of those, and anyone who has additional questions can put them in the chat. Okay, I'm going to start with Ron from Calgary. So, so Ron, it sounds like you're Canadian, so your rules might be a little different from other people. But the question is, what should I do if I'm detained during entry without any reason? Okay, so if you mean detained as in put in secondary inspection for a few hours, unfortunately, there's nothing that can be done about that. Just answer the questions and you're very likely to be admitted. More likely, I think you mean, what if you're arrested and put into the, the immigration detention system? So for anyone who is put into immigration detention, rightly or wrongly, what your remedy is you have a bond hearing. You have to be bonded out, meaning you have to be prepared to make a payment to get out, and then you will receive that money back once your case is all cleared up. Okay, so what you're going to need of an immigration attorney who can assist with bond. Okay, and anyone can email me about that, and I'm happy to provide referrals. We do not personally, because that is on the deportation side. So at Global Talent, we don't do those kinds of hearings or cases, but we can provide a referral. So having that name and that information, that's the best way you can be equipped to deal with that situation. Okay, and then the second part of the question is, U.S. Customs is located in Canadian airports, so will they turn me away while I'm still in Canada or wait till you land in LA? So it is likely, though technically it could happen either place, you're much more likely to just be turned away in Canada than, pre-screened in Canada and then have trouble in the US. It's possible but unlikely. And I see, Ron, you had also a question about O1 approval rates and processing times, which I will get to. Okay. First, I want to answer questions that are a little more directly related to the policies I just talked about. Okay, Camille, also from Montreal, um, says, as a Canadian citizen currently living in Canada that has an O visa, do I need a real ID? Um, so the answer to that is no, you do not need a real ID. You only need a real ID when you're in the US and you're seeking to, travel domestically. But again, if you don't have a real ID, you can use a valid passport in place of a real ID. Okay, next we have Matt from Pasadena asking, does the war in Iran have any effect on EB1 petitions? So, Matt, the EB1 has two parts to the process. Okay, in the first part, it's the I-140, determining if you're extraordinary. And then in the second part, they're uh, they're checking your criminal history, your immigration history. They're looking for any problems with those things. So the war in Iran will have absolutely no impact on the first part, on the determination of whether you have extraordinary ability. Now, in the second part of the process, if you're in the United States, if you're a citizen of any, okay, right now, one thing I didn't mention as part of one of the bans, there is a ban, USCIS implemented a ban on benefits for citizens of, I believe it's 39 countries. So if you are from those 39 countries, you will not be able to process the second part of your green card application. If you're outside the US, then, if you're from any of the 75 countries, you can't process the second part. So Matt, I guess the answer is for one processing, country of origin will have a big impact on whether or not you're going to be successful or you're going to be able to complete that process. Okay. If you are from a country that has no bans, no restrictions, then the war should not have any impact on an EB1 case. Okay. Kat in Los Angeles asks, will the new 1040 IRS form affect O1 visa holders or just green card holders? Okay, so Kat, I think what you are talking about, the 1040 tax form this year for everybody who's paying U.S. taxes, they've restructured the form a little bit, and there's now a box that people have to check to say whether you are a resident or not. And whether you're a resident for tax purposes is actually completely different than whether you're a resident for immigration purposes. So you're going to have to ask your accountant, and usually tax residency is based on how long you're spending in the US. So I cannot advise on tax issues. Definitely not. It's kind of an Achilles heel for me, unfortunately. So you will have to ask your tax expert. But thank you for pointing out that there is a new field or a new box on the 1040 this year. So everyone, please pay attention to that. Ask your accountant when you're doing your taxes. Okay, and the second question is, you had an O1 petition approved in the summer, but haven't gone overseas to do the interview. Is it still advisable to, to do the interview, or is it too risky? So for O1 visa holders from, and again, it depends on your country of origin. Kat, I happen to know you are from a country that is not banned and is not restricted. So anyone who is from a non-banned country, it's still safe to attend embassy interviews and get your O1 visa stamp. Okay. But, it is always best to check. So anyone who does have a question about it can, our existing clients can feel free to email us to get clarification on that. Okay, and then I'm sorry, I don't have the name for this next question, but it's a good question. That says, I am already on an O1 visa. How soon should I start filing to renew in this current political climate? Can I use my past evidence still to satisfy part of the requirements. Um, so these days, we're recommending, because USCIS processing times are quite long, anyone who can start the process to renew a year in advance, you may be able to avoid paying the premium processing fee, which is now $2,965. So it's basically $3,000 to use premium processing these days. Um, so start a year in advance if you can, and hopefully you won't end up having to pay that premium processing fee. Um, the next part of this question is, should I just apply for the green card after a year on the O1? So, whether you should apply for the green card or not, it doesn't have anything to do with how long you've had your O1 visa. It has to do with your background and your credentials. Okay, so I think it's fine to apply for the green card when you're well qualified. Whether that means you have the O1 for 1 year, which would be very unusual, or whether you've had the O1 for 6 years or 9 years, which is more common. But you should move forward with the green card when you qualify. Um, let's see. So let's see what else we have. Sorry, looking obviously at another screen here. I have to check. So, looks like there's a bunch of questions. Okay, let's start here. For O1 visa holder born in China but holds Canadian passport, um, with a Canadian passport with O1 on the Canadian visa, does this cause complications or history of detainment? So for anyone traveling with a Canadian passport, if any history of detainment would generally be based on either a previous arrest or that kind of political speech that I mentioned earlier. But just by virtue of being a dual citizen of Canada and another in China, which is a non-banned country, I'm not aware. I don't anticipate any issues traveling with the O1 under those circumstances. Okay, next question is, under the current policies, how long should a filmmaker prepare for the EB1 process, and what's the timeline like for each part? So how long someone should take? It's not a matter of time; it's a matter of the quality of the evidence. So really, there are 10 criteria that the government considers when they're considering approving an EB1 green card case, and so you want to meet as many of those as you can, but also um, try to meet them with evidence that is going to be of the highest quality. So, meaning that if one of the things they consider is there press or media that talks about you? Okay, and so as everyone knows, there's an immensely wide range of quality of publications. So, a small local publication is not going to be technically it is public it's a published article about you, but that's much different than an article that's all about you published in the New York Times or Vanity Fair or one of the very, very prestigious national publications. So for the EB1, especially right now, what we're seeing is that USCIS is really focusing on the quality of the evidence. And they're saying, like, well, technically, you have minimal evidence to meet the criteria, but really for approvals, especially right now, they're really looking for the quality of the evidence to be of the highest caliber. So it's not a matter of time. You want to just take as much time as it takes to really get to, a high level with high quality evidence. And also for filmmaker, the best chances of success for filmmakers, in my opinion, are generally going to be working on commercially successful projects. Okay, so blockbusters, big TV shows, household names. That's not the only way for a filmmaker to get to an EB1, but those tend to be the strongest cases. Otherwise, you just really want to make sure that your independent films have a lot of press or other kinds of acclaim and success. Uh, let's see. Let's go here. How difficult is it to go from an O1 visa to a green card? Let's see. So generally, it is for people who are in the arts, it is a bigger leap generally than people who are in business and science. Okay, the business and science, the O1A for people in business and science, the criteria for them is closer to the EB1 criteria than it is for artists. So I think that it is a significant jump to go from an O1B in the arts to EB1. The quality of the evidence has to be much better, and the standard for approval is much higher for the EB1 than it is for the O1. Okay. So I see more questions, but I am not able to access them. Let's see. Okay, as a green card holder, this is a good one. Thank you for asking this one. As a green card holder, is it a good idea to apply for a re-entry permit before leaving the US to visit the UK, even if it turns out being for less than 6 months? Okay, I'm glad you asked about this re-entry permit and about preserving residency, because I didn't mention this in my little monologue, but this is something that we're seeing is tougher under the Trump administration is extended absences for green card holders. So a reentry permit, so when you have a green card, you are supposed to be in the US for at least 6 months each year. That's the rule of thumb. For anyone that knows that they're gonna be gone for more than 6 months, or that they're gonna be gone in and out, but gone most of the time for a year or more, in order to preserve your residency and make sure ICE doesn't, not ICE, the Customs and Border Protection doesn't try to take away your green card as you're entering, you can apply for a reentry permit that shows your intention to preserve your US residency. So if you're going to be gone for more than 6 months and you have a green card, you should definitely apply for a reentry permit. Okay. If you're gone for more than 6 months, when you come back, they should try to take your green card for a trip that lasts more than a year. But anything more than 6 months can, be problematic if you apply for US citizenship down the road. So if you're gone for more than 6 months, we need to apply for a reentry permit. Now, if you apply for the reentry permit and you're not gone for 6 months, you're gone for 4 months or 3 months, there's no harm done in that. Okay, so if you think you might be gone for more than 6 months, I would suggest apply for the reentry permit. Okay, and the processing times for reentry permits right now, they're silly. They're like a year and a half or something, but you travel with the receipt and it shows your intention to make US residency. Let's see. I think, okay, so I think that's all the questions kind of related to the policies. I did get quite a few questions about like O1s and EB1s. So let me see what I can say about those. If I can find them here. Okay, O1 visa processing times and approval rates. I think I did answer that one before. I already talked about kind of changing from the O1B to the EB1. Okay, how have O1 visa applications changed from 2 years ago? A very good question. That's Marie from Copenhagen. So The biggest difference that I'm noticing, actually just in the past 4 to 6 weeks, I'm thinking that USCIS is using AI more in their adjudications. I'm noticing any notice that I'm receiving, like a request for additional evidence, you can tell if it's written by AI, and some of them are definitely written by AI. So, how does that impact the cases? So up until now, we're not really seeing any decrease in the O1 approval rates. Um, in the past month or so, we are seeing, a wave of requests for additional evidence being issued, which we're hoping is just, this happens in immigration practice, whether it's once a year, every couple years, we get a bunch of RFEs, and then we don't get more for quite a long time. So we're going to hope that that's what we're seeing right now with the RFEs that have come in the past month or so. Um, but in terms of what kind of evidence they're accepting, I'm not really seeing much difference between now and 2 years ago. So it's still important that you have job offers and that you can show the companies or the projects you'll be working on are, somehow notable or important. And also to show that you have a history of working on projects that have some success. So I think, USCIS is still being tough on film festivals. That's something that started probably more like 3 years ago. So, in the past, we would talk about film festivals in almost every O1 case for someone that had films in festivals. Now, we really only talk about very, very high quality festivals because USCIS often takes a position that um, having films in film festivals is not actually an achievement in the film industry anymore. Um, let's see. Okay, I have a question from Dr. Rafiqul in Dhaka. Let's see. So, okay, you filed an EB2 NIW approved in November 2023. Congratulations. That's a tough category. It's actually very, very tough right now to get approved for NIWs. Everything's current. Final action, filing date, all current. Great. Due to significant backlog of interview schedule dates for Dhaka in Bangladesh, you're waiting for the interview. Okay. So the question is, if you travel to the US on a B1, B2, can you change your status uh, from immigrant visa processing to I-485? Okay, so yes, you can. You want to, the issue that comes up here, when you enter the US on a B1, B2, you are coming in as a visitor, and your intention in that case is to depart the US after a short visit. So the problem is, if you then apply for a green card or permanent residency once you're here, as part of that permanent residency process, they can question what your intention was when you entered. Okay, so what the law does allow here, if someone enters on a non-immigrant status, like a B1, B2 student visa, if during their temporary visit, their circumstances change, if the circumstances change after 90 days, then you are able to adjust status, but are you going to be able to convince immigration authorities that your intention when you entered was to depart or not? So, um, perhaps we should discuss that separately. But thank you for your question. Um, and so I think that's all we have for today. So I really want to thank everyone for tuning in, and um, I don't know, I'll hope to hear from anyone who has questions.
Thank you all for joining us today. And thank you, Liz, for walking us through these important developments and helping bring clarity to what is, for many people, a very complex and evolving situation. As we've discussed, the immigration landscape is changing, often in ways that are not immediately visible, but that can have very real consequences for visa holders, green card holders, and families trying to navigate the system. Staying informed is critical, and conversations like this are an important step in understanding not just what is happening, but how those changes may impact you moving forward. On behalf of Global Talent Immigration Law Group, we appreciate you taking the time to be here with us today and to engage in this discussion. We'll continue to monitor these developments closely and provide updates as things evolve. Thank you again for joining us, and we'll see you next time.